Good evening, this is John Milburn. This is Laws 19038, Planning and Environment Law. It's week 11. We're dealing with a number of issues tonight, but I want to start with some comments in relation to the alternative dispute resolution process, mediation and conciliation in particular. I guess the concept of mediation is pretty simple and pretty well known. People come together with a view to resolving the disputes and hopefully coming to an agreement, which in the context of P&E law can become a binding agreement. Conciliation is very similar to mediation, but it's mediation where the conciliator has more power both to intervene and make make suggestions, intervene and give some indication as to likely prospects of a matter resolving, and then finally having power to make decisions by way of order, not to determine who's right or wrong, but to make some specific orders in relation to the ongoing process of the matter. So that's conciliation. It's a bit more involved than mediation, but very similar. So in both forms of ADR, what the person in control wants to do is ensure that the parties can identify the issues of concern, develop options in relation to those issues, maybe consider some alternatives, and hopefully come to an agreement. Conciliators can provide advice, as I mentioned before, so they may have some special experience or special expertise. In other words, conciliators are more directive and advisory, whereas mediators are much more focused on empowering the parties rather than taking any form of power in the process themselves. But conciliation or mediation is very often a part of process now in litigation. It's certainly a very important process in planning and environment court litigation. And it may be that there's a decision needs to be made about whether it should be mediation or conciliation. Conciliation is often favoured in circumstances where there's no legal representative, because the parties can get some advice on the way through while they're trying to resolve the issue. Conciliation might be more relevant where there's a technical dispute or dispute that involves legal matters. So having someone with some experience and knowledge might be able to assist as well. Mediation and conciliation can be very flexible in the way it's delivered. It doesn't have to be all parties in the same room at the same time. It could be in the same building, but in different rooms, and the mediator shuttles between the two, or it can be by audio-visual, or it could even be through exchange of correspondence, emails, etc. in some situations. But typically, mediation or conciliation will follow a familiar form, and the parties are greeted. The parties have an opportunity without interruption to voice their initial concerns in an opening statement. The mediator will then try to identify the issues with the agreement of the parties. Then typically there will be some discussion about those issues, and if it hasn't resolved, there will often be private meetings where the conciliator or mediator speaks to the parties involved, maybe to give some reality testing, maybe to give some idea of what they think is the likely outcome. Maybe think about the strengths and weaknesses and talk about what might happen in a very candid way if they don't resolve the matter. But what is common for mediation and conciliation is that the person in charge, if you like, of the process is not the person who makes the ultimate decision. The process is confidential, meaning that if there are concessions made or offers made during that process, they can't be raised in litigation at a later time. So it really is an opportunity for the parties to get their heads together and try to come up with something which will resolve that issue. It also provides them with an opportunity to be creative and flexible in the way in which they come up with their agreement. It doesn't have to be purely focused on what is contained in the litigation. It can be broader than that. And there may be an opportunity for good relations to be improved or maintained through the mediation or conciliation conference. So they're the main issues as to why you might have that. role, and I've sort of briefly indicated the difference between a mediator and a conciliator. The opinion of the mediator will not be voiced, because in pure form the mediator doesn't offer an opinion. The opinion of the conciliator can be voiced. That will be done very sensitively and very carefully, typically, most often in private session only. And because the conciliator is a person who usually has some degree of authority or experience, what they have to say is likely to be considered very seriously by the parties. So it can work in that sense, in that it might help resolve the issue at an earlier time. Okay, now I just want to talk in the context of planning and environment court litigation about the concerns that should be had or might be had by objectors or submitters, if you like. People that are taking the matter to court on the basis that they're concerned about a particular development. And you've seen examples of that. The video involving Roger Curry is excellent in terms of the way he talks about the risks and issues that face community litigants who are challenging something. Also, you've seen that in the Predajon case, the way in which submitters and objectors get involved in the litigation. So let's run through some of the issues that are facing, I suppose, all litigants, but in particular community litigants, objectors and submitters. Well, there's cost, there's time, there's the dynamic of having to deal with a group. There is the risk of internal disagreement between members of the group. There is the issue of how does the group express its voice and its opinion. Do they appoint one person who has authority to make decisions, or to, if you like, represent that group? So there's the whole group dynamic issue. Then, of course, it's the matter of the group, the community litigants, understanding the role of experts. And this can't be understated. Experts play a vital part in planning and environment court litigation. You would have seen that from your reading. But they don't come cheap. So there is the issue of paying those experts, and raising money is always an issue. Now, litigants need to be aware of timeframes, and community litigants run the risk of missing strict timeframes. Also, when they walk into a court or a mediation session, it's all going to be very unfamiliar to those people who typically aren't legally trained. They have to comply with practice directions and rules, and we talked about that a few weeks ago. They have to prepare affidavits. They have to be done in the appropriate and acceptable form. They have to somehow understand the protocols in court. They should have a look at that video by Judge Morzone in that regard. They need to understand the protocols and the systems associated with mediation and the court itself. And of course, they need to ask themselves the right questions. Some of those questions might be things like, how do you feel your prospects are of success? Do you think that you are a realistic prospect of winning this particular litigation? How do you wish to achieve that? What do you actually want at the end of the day? What's the thing that you really want to achieve as a result of all this? What are realistically your strengths and weaknesses? And very important, going into a mediation session or litigation, think about what is the worst possible outcome for you? WATNA, as we call it, the worst alternative to a negotiated agreement. Or the BATNA, the best alternative to a negotiated agreement. But think about the consequences of not resolving the matter at mediation. Think about the consequences of embarking on litigation. But the thing I haven't said yet, which is the biggest one of all, is the issue of costs. We talked about costs last week and the week before, but it is an important area. Prior to changes that were made in November of 2012, courts generally were most reluctant to award costs against people who were community litigants but acting in good faith and could substantiate their concerns, particularly if those concerns were in the public interest. But the new cost rules create much greater risk and much greater uncertainty. Now, the general rule of court previously was that parties pay their own costs. It doesn't matter who wins. And we see that in other jurisdictions, family law, domestic violence, etc. But as at the 22nd of November 2012, the general rule that the parties pay their own costs in planning and environment court litigation no longer applied. And the new rule is that costs are now to be awarded at the general discretion of the court. In other words, the judge who hears the matter will make a decision as to who pays the legal costs. Now, in general civil litigation, as opposed to planning and environment court litigation, the Uniform Civil Procedure Rules apply generally in the sense that the loser of the litigation will almost invariably be expected to pay the costs of the successful party. We talked last week about the different types of costs, party and party, which is at a set scale, as opposed to solicitor and own client, which is typically much higher. When we talk about costs, usually we're talking about an award on a party and party basis, not usually indemnity or solicitor and own client costs. But anyway, the general rule under UCPR is the loser pays. UCPR applies in planning and environment court litigation as well, but not exclusively. We talked about the special rules and procedures that apply in planning and environment court in previous sessions. So in the context of costs, it's not going to be necessarily the case that the loser pays. It is still a matter of discretion for the court. But the court will consider not only who won the case, but also the relative success of the party that lost. You know, in simple terms, was it a walkover, or did the losing party really have a good argument but not quite enough to win the case? The court might consider, what was the purpose behind bringing the proceedings in the first place? Was the purpose malicious or vexatious? And if so, they're much more likely to be awarding costs against that party. The court might say, well, was the unsuccessful party realistic in its assessment of the prospects of success? Were there public interest issues as well as interests relating to the particular litigants involved? Did the unsuccessful party act reasonably throughout the proceedings? Did they disclose appropriately as they went through? Was there a willingness to undertake ADR processes? Did they comply with the rules? Did they act reasonably in the conduct of their case? So these are all sorts of things that the court might consider in the context of costs. And we're not talking small amounts. The costs order could easily exceed $100,000. So if you happen to be advising a party which is, or a group considering entering into planning and environment court litigation, you would be remiss if you didn't speak to them about that issue of costs. All right, are there any questions as we progress? Any comments? Otherwise, I'll keep going. I know there's a lot of information tonight and I'm moving pretty quickly. Otherwise, I'll continue. All right, in previous sessions, we've talked about compliance and enforcement. So it may be apparent from you, to you, in considering, I suppose, initially the Predijon case and then more recently the Byrne Brothers case that I set by way of assignment, that regulators deal with environmental process in two ways. Number one, dealing with the issue of approval or rejection of an application for development consent, for example. And if there is an approval, what conditions should be imposed. Now, that's one thing that regulators do. The other, if you like, opportunity for regulators is to deal with offences. In both instances, in the approval process or the process of dealing with offences or transgressions, the issue of conditions may be raised, because conditions are really a very important part of this whole process. So the way in which regulators deal with the issue of failure to comply with conditions is something which is not set in stone. There are different ways that regulators can deal with these issues. One way that you've seen in the commentary in the Byrne Brothers case is that the process may result in breach proceedings and enforcement proceedings. Now, enforcement proceedings can be conducted through the Planning and Environment Court, and I'll make some comments about that later. But before I get onto that, I'll just mention briefly again criminal proceedings. We talked about crime, I think, last week. Just a quick revision. Crime is, if you like, or criminal proceedings, prosecution, is usually regarded as a last resort. It would normally follow consideration of civil proceedings or administrative proceedings. But if criminal proceedings are brought, you need to consider, okay, what is the nature of the crime? And I'm using that in a very general term, the word crime, as opposed to a specific term. Is it an indictable offence, which is a more serious, or is it a summary offence? And you recall under the Environmental Protection Act of 1994, indictable offences carry a maximum term of imprisonment, potentially, of 2 years or more. So they're the more serious matters, and indictable offences are typically dealt with in the District Court or the Supreme Court, or in the context of planning and environment in the P&E Court, which is really the District Court. And indictable offences will typically proceed through the Magistrates Court in a committal process to eventually get to that higher court. When the matter is determined, this is criminal proceedings determined by a court, there are a number of options available to the court. Obviously, jail terms could be imposed. If jail terms are imposed, there are different types: actual jail, suspended sentence, release on parole, intensive correction orders. There's a number of different types. But courts could impose a jail term, custodial sentence of some sort or another. They could, of course, impose fines, but there are a whole range of other things that are available to courts now in sentencing in criminal law matters, such as orders to make public benefit orders or to restore the environment, which is essentially to restore the environment, or it might be a monetary order or an education order or a publication order. So these are different things that the courts can do in terms of the orders that are made. All right, so when it comes to sentencing on a plea of guilty or a finding of guilt, courts will consider a number of things, and that might be, for example, whether it was a plea of guilty. There'll be a discount for a plea of guilty. Was there cooperation with authorities? Discount. Was there contrition or remorse? Discount. What's the likelihood of repeat offending? Discount. Circumstances of the defendant. Was the defendant elderly, aged, particular circumstances, etc. So these are things that a court will consider in the sentencing process. All right, before I leave the issue of criminal proceedings, I'll just mention briefly that there are probably two common defences which might be raised in environmental law criminal prosecution. One is a defence of due diligence, and the other is a defence of honest and reasonable mistake of fact. In relation to the concept of due diligence, can I just say that essentially the defence says, well, I did everything as well as I possibly could. I followed guidelines. I was my compliance was followed due diligence guidelines. So in order to establish that defence, you probably want to look at what was done leading up to the issue that led to the prosecution. Did the defendant have environmental management systems in place? Did they comply with those systems? Did they complete an audit process? Was that audit process voluntary or mandatory? So it would be easier to establish a defence of due diligence if you've done those things. Conversely, it would be much harder to raise that defence successfully if you hadn't done those things. So if you're advising an organisation that may be involved in some sort of breach, if you like, or transgression of environmental law issues, you might want to raise with them, have they complied with those sorts of requirements? Okay, so that's criminal law, but as I mentioned, that's only one of three general ways in which regulators can enforce the environmental laws or the planning laws. The others are civil proceedings, and then there's administrative proceedings. So in the exercise involving Byrne Brothers, you would have seen an example of administrative proceedings which have been taken to the Planning and Environment Court. There are a number of different ways that matters can be dealt with administratively. For example, the minister may make an interim conservation order for conservation or protection or management of wildlife or habitats or areas of major interest or protected areas. And that's under the Nature Conservation Act of 1992, Section 102. But generally speaking, a government agency can make or issue an enforcement order or notice if it reasonably believes that a person has committed or is going to commit a development offence. That's the Sustainable Planning Act, Section 590. And as you would have seen in the commentary to do with Byrne Brothers, there are provisions in the SPA which allow for a complainant to prosecute for a development offence, and that can be brought in proceedings in the Magistrates Court or in certain circumstances in the Planning and Environment Court, which is what we were considering. And that's if it's an interim, if it's for an enforcement order or an interim enforcement order under Section 601 of the Act. So an enforcement order can be made if the court is satisfied that the offence has been committed or is going to be committed and it needs to be restrained. And there are different types of orders that can be made. The order may require an undertaking, or it may order the cessation of activity. It may say you've got to stop the activity. Or it may make a declaration pursuant to Section 456 of the SPA. A court has power to declare what the law is in relation to a particular issue. I know I've been speaking very quickly and I know there's a lot to take in, but I hope that what you've seen is through the last exercise involving various matters, we're trying to raise different ways that the enforcement agencies can go about their activities. All right, well, I'm just about ready to wrap up. I will just remind you to understand and consider the difference between a merits review and a judicial review. We'd previously covered this, but have a look at Chapter 20 of the text in Bates, and that provides a really good outcome or outline. All right, so I'll end the meeting shortly unless there's any questions. Does anyone wish to ask any questions, make any comments?
Just a quick question, John. How would you prefer us to reference the documents that were in the Byrne Brothers case?
Oh, sure. Say, for example, it's an affidavit. I would like you to reference it as affidavit of Joe Smith and then perhaps the paragraph number. So the date of the affidavit and then the paragraph number. Is that sufficient?
No worries.
Great, thank you.
Yes, thank you.
Great. Any other questions, comments? All right. Well, I might stop recording at this stage and thank you very much for attending. Bye.